Welcome to our Stowe Talks How-To series. I am Abby Jones, a solicitor at Stowe Family Law, and in this video we will look at how you apply for and obtain a Section 9114, also known as a barring order. For the purposes of this video, we will call them barring orders and cover what a barring order is, why you would need to get one, how to apply, and the factors the court considers when approving one. A barring order is an order made by the court that prevents an individual from making an application to the court about their children without first seeking permission from the judge. A barring order covers applications made under the Children Act for things such as child arrangements orders for contact or variations of contact. Its purpose is to prevent unwarranted, unnecessary, and disruptive applications being made which are often without merit. You'd apply for a barring order when there have been continual, unjust, and unreasonable applications made by an individual over arrangements for children, and it is believed that further applications would place the child or other person at risk of harm, or it is in the child's best interests to make this order. Sometimes the order is required where there needs to be a period of rest after lengthy proceedings, or time is needed for actions to be taken to ensure the safety of children or the other party, and they should only be used as a last resort. You apply for a barring order by filling out a Form C2. On the form you'll be asked to provide details about you and the children, people who should be giving notice of the application, and a statement including what you are applying for and why you are making the application. It is a complex form and it's highly recommended you seek legal advice to help you complete it correctly. The evidence you will need for a barring order application is full details of the harm experienced to date by the continual and unreasonable applications, evidence of abuse already suffered, and evidence of threats to continue the court applications. The court may also request expert evidence on the risk of harm caused by making continual applications. You will have to go to court to get a barring order, and more often than not, these circumstances arise during current children proceedings. The factors the court considers before approving a barring order are the risks of harm of continuing court applications to the carer, parent, and child. It is usually ordered where those continuing applications are causing or deemed to cause harm. The court will weigh up the welfare of the child, the risk of harm, and the restriction on the individual's ability to make an application to court. A barring order can last for the time the court deems necessary. However, the duration must be proportionate to the harm it seeks to avoid. Once your barring order is granted, it will specify what applications are not permitted without the permission of the court. If the individual named in the order wishes to make a prohibited application before the barring order expiring, they will need to seek the court's permission for the application. If the court does not grant permission, then the application will not be allowed to continue. The importance of legal advice. It is important to speak to a family lawyer because barring orders can be complex and tricky to obtain. A lawyer can help you with your application and supporting statement and ensure you have enough evidence and detail to convince the court the order should be made. Having to endure repeated court applications and hearings over arrangements for your children is extremely stressful for the parent and children involved. A family lawyer can give your case the best chance to save further coercive court proceedings being started. If you're in immediate danger from domestic abuse, please call the police. Help and support can also be accessed from the National Domestic Abuse Helpline on 0808 2000 247 or visit www.nationaldahelpline.org.uk. For more Stowe Talks, how-to videos and further free resources, visit stowefamilylaw.co.uk/support.